Hello, Colorado Realtors. I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. So, we have a new contract to buy and sell. You lucky realtors, you. I know you love this. Form changes. So, effective January 1st of this year, 2019, we got a new contract to buy and sell. And effective just within the last couple of weeks, the Division of Real Estate, or the Real Estate Commission, has promulgated a new contract to buy and sell. And it's pretty exciting, let me tell you. But there's some important changes. There's not a lot of changes, but there's an important change, and it's in paragraph 13. There's also some new closing instructions that have some more significant changes, and I'm going to talk about those in a second as well. But the contract to buy and sell, and this is to each of the individual contracts to buy and sell, the residential, commercial, investment, etc. All of them have the same changes that were made to paragraph 13. And paragraph 13 got more simple. So we changed paragraph 13 in the new contract to buy and sell effective January 1st, and it's changed again. And I won't get into all the background and history of why the quick changes. What it comes down to, though, is that, and we don't do this often because we've got a forms moratorium, as most of you guys know. Once the Real Estate Commission modifies a contract on a calendar year basis, that form is essentially locked down for 3 years and doesn't change again. So to change within a few months is pretty unique. In fact, it's very unique in my history with this Division of Real Estate in the process. But the moratorium has only a couple of exceptions. One of those exceptions is a change required or mandated by the legislature, a legislative or statute change that requires a change to the forms. Well, that's what we have here and occurred in this case. It was because of what was House Bill 1098. And House Bill 1098 was, I think it's got to be one of the only, or maybe the only, bills in the entire legislative session that just ended in May that passed both the House and the Senate unanimously. Go figure that. And was signed by the governor on an expedited basis and became law effective immediately. And so it was what we referred to as the Deeds Bill, essentially. And the Deeds Bill did a couple of things. It revised and sort of modernized, I guess the easiest way to say it, the statutory form deeds, which is the general, special, bargain and sale, and quitclaim deeds. Those 4 deeds got some cleanup and modernization, all good things. The legislature created statutory exceptions to those deeds. So the event that there's a general or a special warranty deed and there are exceptions to those warranties, there are statutory exceptions now, and those are memorialized in statute. And so those should be reflected then on the general or special warranty deeds that the parties use in closings now, effective going forward in the state of Colorado. And then the other thing it did is it authorized title companies to prepare deeds. Title companies have been preparing deeds functionally and practically for a long time. They've been doing so on your behalf through your license, your ability to prepare deeds under license law. You would then give them a scrivener's agreement and pay $5 or whatever it was, and the title company would, on your behalf and through your license, essentially prepare a deed for the transaction. And so that went away as well, and now title companies are able to prepare their own deeds in connection with issuing title insurance, right? So they can now prepare the deed under their own license that came through this new change in statute. Brokers, just FYI, you guys can still, realtors, you guys can still prepare deeds. I would discourage you heavily from doing that. I think almost nobody does, but nothing changed with your licensing or ability to do that. If you choose to prepare deeds and close transactions, you can still do it, but very risky business playing around in that field, so do so incredibly cautiously. But in any event, so these new forms, paragraph 13, had to be updated to reflect the House Bill 1098 changes and that came as part of the deed bill. So you can use the form. The form is available now, and it has been for the last couple of weeks through the Division of Real Estate's website, and it should be uploaded, I think, through maybe your forms providers as well. Hopefully that's been done by now. So it's available to use now, and I would strongly encourage you to use it now on all new contracts. It becomes mandatory. You have to use it. You can no longer use the new contract, which is the one that was effective January 1st. You can no longer use that after July 1st of this year. So you've got a little bit of a phase-in period, but I would strongly encourage you guys to, if you're writing new contracts, to use the new contract, the new contract that hopefully is available through your form providers at this point. And then as a result, you're also going to be using the new closing instructions, because the good news about brokers not being the ones that are preparing deeds or having deeds prepared through their license and the title company is going to do it themselves, title company takes on the liability for the preparation of the deed, and it shifts, and so no longer does that liability flow through the broker and through the scrivener's authorization. So that's a good thing for brokers. So use that new contract now. So what changed with paragraph 13? It got a lot more simple. Now there's just boxes you can check, general, special, quick claim, bargain and sale, or other. And that would be a personal representative's deed maybe, or a trustee's deed, beneficiary's deed, what are effectively bargain and sale deeds anyhow, but you know, there's a way to name them if you want to name them. But there's still just those 4 statutory form deeds. If you don't do anything, if you don't check any box, then the contract, what will be given, the default is a special warranty deed is what will be conveyed. So, but now it's a lot shorter. You're picking that, and there's a little statement that says if exceptions other than the statutory exceptions that were created by the deeds bill, if there are exceptions that the parties want the deed preparer, in most cases the title company, to specifically list, then they have to give specific instructions to the title company to do that. So what that would look like is that the parties, buyer-seller would say, you know, deed to be prepared with, you know, with all exceptions listed, statutory warranty deed to be prepared with all specific exceptions listed, as opposed to the statutory exceptions listed. And that would go in the additional provisions. And my guess is then the title companies are going to probably hit the parties with a form saying, okay, well, you tell us what exceptions you want listed. I think I'd be cautious with that as a broker. If your parties are instructing that to happen, then let them complete that form and let them enumerate what exceptions they want specifically listed. I think as a broker, if you're going to be doing that, you're going to be stepping right back into that liability chain that you kind of get out of through this change in state law. So do that very cautiously, but it still does give them the ability to do that if you want to address it in the additional provisions and then by some kind of supplemental form. The other thing that we get is new closing instructions, and so because the scrivener's agreement became removed, we had to go in and deal with the title company's preparation of that deed form. So there's some new language there, and then there's also some new language in relation to the bill of sale that title companies often prepare, and kind of closed a little gap that I think was missing in the closing instructions previously. I would really encourage you guys, as I have for a long time, to use the Colorado Commission approved closing instructions. Do them at the time of contract, submit them, and that's your one set of closing instructions for the transactions. You don't get into a situation where you're allowing the title company to prepare a second set of closing instructions, and then you've got, you know, the 2 sets of closing instructions that may not be consistent for the same transaction, and then you got issues with which one applies, which one controls, and it's not the right way to do it. It takes you 2 seconds, do the closing instructions, use the Colorado Commission approved forms that are in your forms library, do them at the time of contract, get them out there, get them done, and then if you're asked or required to sign additional closing instructions other than loan closing instructions, if you're asked to sign by the title company additional contract closing instructions at the closing table, don't do it. You've got a set. That's what's controlling the transaction. So that's what you ought to be using, and I would strongly encourage you for a variety of reasons to be using those new closing instructions. So anyhow, hopefully that gives you a little bit of insight on what's going on. We've got some events coming up with the Colorado Association of Realtors. Check those things out. Love to see you at our events. And if you have questions on the new paragraph 13 or the new closing instructions or anything else, as always, Car Legal Hotline's available from 9 to 4 and 9 to 12 and 1 to 4 Mondays through Fridays. So love to hear from you there as well. Thanks so much for joining us again.